The first case I want to call is State of Ohio versus Michael McVey. I believe Attorney Charles Bean is here representing the defendant. You may proceed. You may proceed, Attorney Bean.
Thank you, Your Honor. At this time, we would enter a not guilty plea to each and every count of the indictment. We would also acknowledge receipt of the indictment and ask that Mr. McVey's own recognizance be continued.
The court will accept the plea of not guilty and on behalf of the client. The court will continue the personal recognizance bond previously ordered. And I'd like to set this case for a pre-trial after the discovery has been finished in this case. Are you available on January 17th at 11 o'clock?
Yes. Yes, Your Honor.
All right, the court then will set this case for pre-trial January 17th at 11 a.m. Same time to continue.
Your Honor, we this morning filed a number of things in all of these cases. One of the things we filed with regard to Mr. McVey was a motion to amend the indictment. I'll make sure that the court has a copy of this. I've served counsel just now. There was a what we believe to be a typographical error with regard to the dates. There was a starting date with a dash, but we didn't put in the end date, and we're asking that we be allowed to amend the indictment to change that to the proper date as spelled out in the motion.
Entertain a motion pursuant to Criminal Rule 7D.
Yes.
Conform to the evidence.
Yes, Your Honor.
All right, well, let's give counsel an opportunity to look at the information, the full discovery packet. At that point in time, the court will decide whether or not it's subject to proper amendment under Criminal Rule 7D.
Thank you, Judge.
All right, State of Ohio versus Matthew Bellardine. All right, and representing Mr. Bellardine today is Attorney Brian Duncan.
Actually, Your Honor, Attorney Adam Neiman.
I'm sorry. Go ahead.
Thank you. Mr. Bellardine would like to notify the court we have accepted the complaint, have no questions, and would waive reading the complaint and enter a general plea of not guilty. Regarding bond, we would allow recognizance to continue. He has no prior record, and his particular charges are misdemeanors only. Thank you.
All right, the court would accept the plea of not guilty to the charges in this case. The court will continue the personal reconnaissance bond. And also, I would like to set this to a pre-trial also on January 17th at 11 o'clock. Are you available?
Yes, we are, Your Honor. Thank you.
And is your client prepared to sign a time waiver?
He just did.
We did, so that we can allow full discovery in this case prior to setting a trial date or working out a plea in this case. All right, January 17th, 11 o'clock, to get your trial, same time to continue.
Thank you, Your Honor.
Thank you, Judge.
State of Ohio versus Lynette Gorman.
Good morning, Your Honor.
Good morning.
Dennis McNamara, appearing on behalf of Ms. Gorman.
You may proceed.
Your Honor, we filed prior to today's hearing a written not guilty plea. This involves one count of fourth-degree misdemeanor that the rules allow that to occur subject to the prosecutor's approval, if they've approved. We acknowledged receipt of the complaint, waived the reading of it, waived our appearance, and entered the not guilty plea.
So we talked previously then about setting a trial date January 7th at 9 o'clock.
Yes, Your Honor, that's fine.
All right, the court will establish a trial date January 7th at 9 a.m. Also, I want to make sure in terms of a speedy trial issue that there is no speedy trial issue without stopping now to calculate.
As to that date, there is not. January 7th, 2014 is within the speedy trial timelines.
All right,
We
and you're
agree to that.
you are stipulating to that?
Yes. Yes, we are.
And the state is stipulating for that as well?
Yes, Your Honor.
All right, very well, then we will go forward on January 7th at 9 a.m. I understand that the trial probably would take approximately a day, is that correct?
Yes, Your Honor.
I believe that's correct, yes.
All right, very well. The court will continue the same bond previously set.
Thank you.
State of Ohio versus Seth Fluharty.
Morning, Your Honor. Tom Tyack on behalf of Mr. Fluharty. We acknowledge having received a copy of the complaint filed in the juvenile court. We have previous to the appearing this morning entered a not guilty plea and a jury demand to that charge. I have just received a file copy from the clerk, so I know it is in process. Discovery is ongoing. And we have signed a waiver in terms of the speedy trial in order that a pretrial could be scheduled on that January 17th.
All right, the same bond will continue in reference to Mr. Fluharty. And the court then, in light of the signed waiver, I'm going to set this for a free trial also on January 17th at 11 a.m. And the court expects all of the discovery then to be completed prior to that date. Thank you.
Thank you.
Is there any other issue that needs to come before the court? We do have State of Ohio versus Hannah Reinhart, which was called, in which I had a pretrial earlier. Stephen Leonard was previously here, and the court also set a pretrial in that case for January 17th at 11 a.m. for purposes of the record. Anything else to come before the court at this time?
With regard to Hannah Reineman, it's my understanding, Judge, that the court also set a trial date for February 20th, 2014 on that case at 9 a.m.
Yes, that's correct. Thank you. And I know the state is contemplating filing some motions for better wording, gag orders in this case. And have you given copies of the proposed order to opposing counsel?
We have not, but we will. We did file the motion with regard to pretrial publicity gag order in the Bellardine case. That was filed this morning, and that dealt with some pretrial publicity last Friday. We have a proposed order that I have shared with the court through the court staff, and I will make a copy of that available to each of the attorneys.
And the court certainly will give the opportunity for any defense counsel to object to that proposed order. I'm going to give, court will indicate I'll give 10 days from today to file any motion opposing the proposed gag order in this case.
This court,
Yes.
Your Honor, I have not seen the gag order, and I am scheduled to be out of my office 4 days next week. And I was wondering if that time when the gag order could be extended. But because I do believe we will oppose it because of the publicity that the Attorney General has already given this case.
How much time do you need Attorney McNamara to file a response to this proposed order? I'm sorry, Mr. Dean, I'll be
That's okay.
I would say that I could file it by the week between Christmas and New Year's. Because this is already the 13th of December.
The calendar says January 2013. Okay, let's see, Christmas is the 26th.
5th.
Or 5th, the day after is the 26th. How about the 30th?
That would be fine, Your Honor.
Okay. And make sure it is filed exactly on the 30th, so the court can deal with it prior to the commencement of your client's trial, Attorney Dean. And also I want to indicate that in the event the court puts on an order, a gag order as we call it, what's good for the goose is good for the gander, and it's going to apply equally to the state of Ohio as well as the defense. And of course, under the case law, any restrictions in terms of comments have to be narrowly tailored to fit the particular case. So the court will take a look at that. I'll take a look at also at the responses from defense counsel, and the court will then decide whether or not to put an order on to that effect. Anything else that must come before the court at this time?
Your Honor, only regarding the other defendants, does the response to the gag order deadline of the 30th apply to all of us?
In the holiday spirit, the court will give you also, all defendants, to December 30th to file a response. If you have any opposition to the gag order. If I don't receive anything from you, then I'll assume that that particular defendant is not opposing such a motion.
Your Honor, I have given copies of the proposed order that we prepared to all the attorneys that are present. There were a couple that have since left because of things we took care of beforehand. I'll make sure they get a copy as well. The only case that we filed anything in at this point is the Bellardine case. We filed that just moments before we came into court, both in the adult and the juvenile number. The other defendants, there's no motion filed, but there would be based on the court's ruling on Bellardine, but it may be an exercise in futility. If the court rules on everything, then we would obviously go along with that order. It's just, at this point, there's only one motion filed, and that's in the Bellardine case.
Yeah, I was trying to save some time, money, and effort in that I highly suspect that if the court grants the state's motion or a portion of the state's motion, then the state's going to ask that it be applied to the other defendants. So I'm just going to give everybody an opportunity right off the inception of this case. If you have an objection to a gag order, file it. If you don't, then the court will put an order on that I feel is fair in this case.
Thank you.
And that concludes these proceedings. Thank you.
All right.
Yeah.